Hello, everybody, and thank you for joining this session on climate justice, new challenges for law and judges. My name is Henrik Andersen. I'm an associate professor at Copenhagen Business School, and I will, together with Professor Alberto Di Franceschi from Ferrara University, tell you a bit about this project that we are working on. Now, climate justice is a very wide concept, and this project we're working on narrowing it down to concern states and corporations' obligations to reduce CO2 emissions, and that would be under the law. One question, of course, what does the law entail in respect to such a reduction of CO2? There have been various cases at national courts concerning this question, and with many interesting yet also different outcomes of it. What we will do here is that we will consider various sources of law and the interconnection and application to questions of climate justice. Questions are many, and they include questions related to locus standi, the role of human rights, the role of international climate change law in the domestic systems, extra-contractual liability, and private international law. The aim of this project is to establish principles that courts and other practitioners they can apply when they handle climate change cases. And we will establish these principles based on the various sources of law, and that would be law both from national level, EU level, from the European Convention on Human Rights, and international level. And we'll look at the range of these laws, their overlaps and potential conflicts. We have received a lot of fruitful impacts from our team members, and we are lucky to have 4 of our team members with us here today, and they will give a presentation on the various issues about climate justice. The first speaker will be Judge Larissa Olwin from the Hague District Court. Our second speaker will be Judge Tim Eike from the European Court of Human Rights. Our third speaker is Lavanya Rajamani, who is a professor of international environmental law at Oxford University. Our fourth speaker is Gerhard Wagner, who is a professor of civil law, economic law, and economics at Humboldt University. After we've heard these presentations, you can ask questions in the Q&A button here on the screen. And after the Q&A session, Professor Di Franceschi will give the closing remarks. Thank you very much, and I think we will get ready for our first speaker, Judge Larissa Olwin from the Hague District Court. Thank you.
Well, thank you very much for the honor of taking part of these discussions, and also for letting me speak first. I will make a few remarks on establishing duty of care on states and corporations in climate litigation. I speak from my perspective as a Dutch judge, and my remarks are based on the Dutch Urgenda case against the state and the case against Royal Dutch Shell, in which I participated as the presiding judge. The stage for duty of care relating to climate change is set by the reduction goals of the Paris Agreement, and the notion this agreement is built on, that a combined effort is needed to reach the climate change goals. And the claims in climate cases aim to remedy the fact that the national determined contributions that were set after the Paris Agreement are not sufficient to reach the goals. The Dutch cases were both class actions protecting the interests of the Dutch citizens. And in both cases, a duty of care was established on the basis, in both cases, of the relevant facts and circumstances, the best available science on dangerous climate change and how to manage it, and the widespread international consensus that human rights offer protection against the impacts of dangerous climate change. And in the Shell case, the widespread consensus that companies must respect human rights that is also laid down in soft law, such as the UN guiding principles on human rights. In both cases, many key issues were undisputed. Parties agreed that the climate change is a serious issue that calls for a reduction of greenhouse gas emissions. There was no discussion that the Dutch state and Shell directly and indirectly control emissions and are able to take measures to mitigate them. The causal chain between these emissions and the risk to the Dutch citizens was undisputed. And both the Dutch state and Royal Dutch Shell, the mother company, were very well aware of the risks and of their own ability to contribute on reducing greenhouse gas emissions. When disputed, these issues ask for highly complex decisions. Though the general problem, the need to take action and the ability to make a contribution was not to be disputed, both the Dutch state and Royal Dutch denied they had a duty of care. They used arguments that were fed by the characteristics of climate change as a mondial problem involving many responsible parties. And I'll name a few examples of these arguments. The drop in the ocean argument, saying my small contribution will not solve this huge problem. The after you argument, why should I have a duty of care when others do nothing or don't do enough? The argument that the Paris Agreement is not binding and that there are no concrete and binding reduction paths and many uncertainties. And the argument that the duty of care will disturb the level playing field. These arguments were all rejected, as was the argument raised by RDS that states and not corporations are responsible for effectuating climate law. In the Royal Dutch Shell case, the scope of the duty of care was an important issue, and the ruling differentiates between an obligation of result for the emissions of the Shell group itself and a significant best efforts obligation for the emissions of its value chain, both upstream and downstream, including the end users. The arguments and the court's reasoning on these issues touch on the macro effects and the effectiveness of the duty of care. And here we see an inherent tension in the judicial task of ruling in a duty of care case on a claim by party A against party B. And these macro effects which have to do with the characteristics of climate change I just mentioned, a mondial problem involving many relevant parties. In general, and also in the Dutch cases, this tension is solved by ruling that the defendants have a duty of care to do their part or contribute their fair share. And based on this duty of care, the Dutch state and Royal Dutch Shell were ordered to reduce greenhouse gas emissions to a certain level in 2020 in the agenda case and in 2030 in the case against Royal Dutch. These orders still leave many unanswered questions, such as how do the state and Royal Dutch have to do their part? Which concrete measures are fitting? And what is the relationship between the duty of care of the responsible actors involved? And is there a hierarchy in responsibilities of the actors involved? And how is the combined effort best organized? And well, these are just examples of the questions that still are open. And many of these questions are in fact general questions concerning the effectuation of the emission reduction in a combined effort that is needed. And many of these questions are out of scope for the judge. They belong to the domain of the responsible parties, and in the Dutch cases, that are the state and Royal Dutch, who are free to determine how they live up to their duty of care regarding future emissions and how they fulfill the order to reduce these emissions. And here we see another inherent tension of climate change litigation. When a duty of care is established and an order, a reduction order is given for the future, this generally leads to further questions that are often out of scope of the judge who has issued the order. And some of these questions can be answered in cases about the execution of the order, and others can never be answered in litigation and have to be answered in another forum. We might see an execution case in the near future, as last June, Urgenda announced that it would take the Dutch state to court again because of not fulfilling the order that was given. But last week, the papers wrote that the order might have been fulfilled anyway. So we'll see what the future brings us. I've tried my best to stay within the 10 minutes. There's lots and lots of other things that can be discussed when talking about the duty of care of states and corporations. But this is it for now, and I'm looking forward to further discussion.
All right, thank you very much. I just need to see if I can get a word from, right, we have to make a small change in the order of speakers. We have some technical problems right now for Judge Eige. So we will then move to our third speaker, Professor Lavanya Rajamani. If you are with us, I cannot see anyone at the moment, so on my screen. So, but Professor, you are, yeah, good, very good. Thank you so much. So next presentation will be Professor Lavanya Rajamani. The floor is yours. Thank you.
Thank you, Professor Anderson. And it's always a pleasure to be part of a panel with such distinguished people on it. And I have had the pleasure of being on a similar panel in the recent past. And it's also a pleasure to follow Judge Alvin. And I'm going to pick up on some of the sort of aspects that she picked up on in her remarks. But my remarks, as you would expect from an international environmental lawyer, will focus on ways in which international climate change law, specifically those aspects of it that enhance climate justice, the topic of today's panel discussion, can actually be advanced through courts, and how courts and judges can plug gaps in international climate change law. And Judge Alvin was speaking to one of those gaps, is the nationally determined contributions sort of emerging from the Paris Agreement are not sufficient, and some of the cases are picking up on that. But I will speak to other gaps in international climate change law as well, with judges and courts can help plug. So to provide a brief sort of explanatory context for why the role of national and regional courts in addressing climate change is so crucial, the simple answer is that the international climate change regime has some fundamental gaps in coverage, and it cannot get the world to the finish line on its own, and it needs national and regional courts and laws to get it to the finish line. So international climate change law, as perhaps most of you know, comprises the UN Framework Convention on Climate Change, the Kyoto Protocol, and the Paris Agreement, and the decisions under them. And this is a regime that has been in the making for over 30 years, but it has had political dysfunction at its heart. Many of the issues are deeply contested and contentious. And the compromises that states have managed to arrive at are located in a sweet spot between the red lines of many parties. So it's a very narrow sort of compromise that states have reached. And so there are significant gaps and weaknesses in the regime. There is a broad understanding of the direction of travel that we are going towards, sort of a global temperature goal in Article 2 of the Paris Agreement, well below 2 degrees centigrade and 1.5 degrees centigrade, aspiring to 1.5 degrees centigrade, and a net zero goal, although that term isn't actually used in the Paris Agreement. There's broad high-level consensus on that, and there's increased transparency around the commitments that states take up for themselves. But there are at least 3 consciously negotiated climate governance gaps in the climate change regime. The first is an ambition gap, what I characterize as an ambition gap, in that contributions that states make are nationally determined, and there's a procedural commitment to actually make these nationally determined contributions and to submit them every 5 years, or update them every 5 years if they're not new. But there is no commitment to actually, or a legally binding obligation to actually achieve the targets or actions that states choose for themselves in these contributions. So this obviously results in an ambition gap because the bottom up doesn't add up. And we see this in the nationally determined contributions that have already been submitted in the second round of contributions that are currently underway. They put us on track to between 2.4 to 2.6 degrees temperature rise, and not to 1.5 or well below 2 degrees. The second gap is an accountability gap, in that although states are required to provide information with their nationally determined contributions, they can choose the informational requirements that apply to them. And there is no robust review function of the ways in which states actually comply with their targets. There is a compliance committee, but it is facilitative. The third gap is a fairness and equity gap. It's a question that has been at the heart of the negotiations right from the start, but states have sidestepped this question, and in particular in the Paris Agreement, with very few options left for actually addressing climate change, fairness, and equity concerns. So climate litigation has actually been pressed into service in addressing these 3 gaps. Judge Alwyn spoke about sort of the ambition gap, as I've characterized it, but how nationally determined contributions are not sufficiently ambitious to meet the long-term temperature goals that have been identified in the Paris Agreement. And we see many such cases. Of course, now famous Urgenda case that Judge Alwyn spoke about was successful in addressing the adequacy and ambition gap as far as the Netherlands is concerned. The Neubauer case in the German Federal Constitutional Court also spoke to the adequacy and ambition gap. The accountability gap is a gap that is being also addressed in national courts, including the Neubauer case, the German Federal Constitutional Court case that I just mentioned, where the decision is actually seeking greater specificity in national climate action plans and an alignment of short-term climate plans with long-term targets. There is a tendency and a trend for many states to take long-term, mid-century net zero targets, but these need to be aligned with short-term actions and short-term commitments. And many of these cases are beginning to ask for that alignment with long-term goals and short-term actions. And finally, the equity and fairness gap is also being raised in national and regional climate litigation, because when courts are approached by claimants who are saying the national ambition is inadequate, they obviously ask the question, against what concrete benchmarks are we to assess the national effort? In the context of a collective action problem, what is each country's fair share? So there are, I believe, 4 cases in the European Court of Human Rights that are currently addressing at some level the issue of fair shares. The Portuguese children's case is one. It's also addressed in some of the national court cases, the Neubauer case. So this is sort of work in progress, and I think it's worth keeping an eye on the fair share question in relation to climate litigation. So climate courts use climate change law in many respects. Many of these cases refer to elements of the climate change regime. Judge Alwyn referred to the fact that the Paris Agreement, one of the arguments that's used by many of the respondents, as it were, is to say the Paris Agreement is not binding and there's no binding trajectory, and there's an argument that was rejected by the courts in the cases that she mentioned. But in many of the decisions, this, at least successful decisions, the elements of the Paris Agreement have been referred to in a positive way and have actually reinforced the international climate change regime. In particular, for instance, the temperature goal of the Paris Agreement, which is characterized and sort of captured in the Paris Agreement in highly caveated and qualified language. However, it's been used and deployed in a far more sort of robust manner in national and regional court decisions. There are also principles of international environmental law that are frequently referred to in many of these decisions, from sustainable development in Urgenda to common but differentiated responsibilities, intergenerational equity in the Neubauer case or the Sharma case in Australia, precaution, again, in the Urgenda case. Courts are not necessarily fleshing these out, but they're referring to and operationalizing these in cases before them, which also strengthens these principles in international environmental law. There are also more general principles of international law that are raised, including the principle of cooperation, which is an important way of getting around difficult issues of causation, for instance. Finally, there are many ways in which international climate change law can be used to help national and regional judges beyond the ways in which they have actually used them so far. There are provisions in the Paris Agreement, as for instance, Article 4.2, which speaks about states taking domestic mitigation measures, and this is a binding obligation, binding substantive obligation to take domestic mitigation measures in furtherance of the nationally determined contributions. And it is a strong hook to rely on when you're trying to challenge, for instance, cases that are currently trying to do this in Brazil, to challenge the dismantling of domestic measures and sort of scale back or regulatory rollback that's going on. There are international law provisions, substantive, legally binding international law provisions that can be used to press into service for preventing such regulatory rollback. There are principles of international environmental law, normative expectations in the Paris Agreement, for instance, in relation to how we determine fair shares in international environmental law. There are a range of objective indicators that states usually deploy to suggest that their contributions are fair. And these are usually subjectively chosen indicators to suggest that their contributions are fair. But if you use principles of international environmental law, you can actually restrict the range of objective indicators and sort of narrow the range of fair shares that states use to demonstrate that their contributions are fair. So litigation is clearly not the best option. The best option would be for us to have internationally sort of multilaterally negotiated agreement that has clear targets and timetables and a compliance mechanism, and everybody does their part. And we get to the finish line very easily, but that's clearly not what we have. And that's clearly not what we're ever going to have. So litigation is part of the landscape, and it's a very important part of the landscape. And it's important, I think, for us as climate lawyers and academics, and for others on this panel as judges, to use international climate change law and international law in a coordinated manner across jurisdictions with reference to case law, to ensure there's sort of cross-fertilization across different cases in different jurisdictions, and ultimately that we're all going towards a shared vision in terms of long-term temperature goals, adaptation and finance goals, and to do this in a fair and just manner. Thank you.
Right, thank you very much. I can see that we start to get some questions in the Q&A box, and I'll just say that we will come back to these questions after we have been through all our presentations. And we will move to our next speaker will be Professor Gerhard Wagner. We are still awaiting the situation with technical issues with Judge Eike. So Professor Wagner, the floor is yours. Thank you.
Interesting panel, one of the most interesting I find. And I also thank my co-discussants, particularly Judge Alwyn, for laying out to us the spectrum of judicial activities in this area. And I wear the hat of the person who is skeptical among the panelists. And I don't doubt the seriousness of the climate change problem and its urgency, but my main proposition is that unilateral action by states or corporations, and even more so by corporations, will not solve the problem and will not even help to solve the problem. That it will not do so alone is, of course, a truism and nothing to worry about. But I also think it might not actually contribute to a solution of the problem. This is a brief recountal. In the meantime, there are many decisions and even further actions pending in courts. They are either directed against governments. That was how the story began in the Netherlands as well, with an action brought by Wagner against the Dutch state, calling for a further reduction of emissions. But there are also, and this is a more recent development, brought against corporations. And the Shell case we heard about is the most prominent example of such an action, not least because it was successful, while most other actions brought against private actors were rejected. And we've also heard about the German case in the Federal Constitutional Court that was mentioned already. Now, what's the problem with judicial activism in this area? And I have, there are many arguments you can make on both sides. Judge Owen has already mentioned the arguments made on behalf of Shell in the Shell case, and I echo some of these arguments and try to put them in perspective. One is, I think, that judicial decisions which force reduction goals on governments or corporations, but particularly on governments, are in the end disenfranchising voters to a certain degree. Because courts do not assume the role of eco-dictators, as they're sometimes said in the media, but I think it's undeniable that they act as paternalists who help voters to overcome their myopic actions that discount the future too much. And you best see it in the German case, I think, where the upshot of the decision is that the climate change reduction goals are kind of taken out of the political process. It is now unconstitutional in Germany for a political party to deny, for instance, that there is climate change, which I find silly, but which nonetheless some people believe. So this is now no longer a political option. This political position is removed from the scope of public discourse and political action. And even worse, it is also true that the balancing of interests mechanism that is the heart of the political process in democratic societies is impaired in the sense that one goal, which certainly plays a role in this balancing exercise, is set at an absolute level. It cannot be mitigated or pushed to the second line. It must be attained. And this is a problem for the political process, I believe. It also means that courts assume some of the responsibility for actually saving the planet. Because if efforts fail, obviously also the courts did too little. But a serious problem really is with the democratic process. I know that this is a rather abstract notion, but I just want to remind you of the fact that in the United States, it has been discussed for a long time whether it was wise for the Supreme Court, for instance, in the abortion issue, but also with a view to segregation, to push ahead so fast and so thoroughly. Whether it would have been better for the society itself, not for the people who objected these goals, but for the democratic evolution of society if the transition had been more gradual. And this is one of the problems with judicial activism of that sort. Another major problem is the question, what will the effects be? Because one assumes that if one jurisdiction, and I now focus on jurisdictions, on countries, reduces its emissions, things will get better with a view to climate change. That will be abated, but this must be questioned. There is even a term of art in the climate change debate called global leakage, which highlights the effect that products and services which are energy intensive, which used to be produced domestically, will relocate to other jurisdictions with lower standards. But the overall impact on the global climate will remain the same or even increase. And if you look at, for instance, the prospects of the auto industry, there is a quite successful, albeit small, Swedish car maker which designs the cars in Sweden, but all the production is done in China. And this is true for many products which we already consume. So the question is not so much how much reduction do we obtain in any given jurisdiction, but we must address the question how much reductions, how much greenhouse gas emissions are caused by the products and services we consume. But these products are produced elsewhere. And if you increase prices domestically, the usual effect will be that production moves abroad where standards are lower. And of course, this also applies to private firms, to corporations, even more so, because private corporations such as Shell lack the resources and the authority and the legitimacy to really transform democratic societies. If you imagine that Shell must use best efforts to reduce the emissions caused by its customers, that would involve a transition of local residential heating systems and of a complete move away from the combustion engine in motor cars. And while this is something to wish for, it seems obvious that it is impossible for a corporation to plan, organize, and implement such a transition. It takes a governmental action, a coordinated action that only governments can undertake. And if these private actors are then burdened by duties to mitigate, while their competitors are under no such duties, it seems, or it's highly predictable that the demand will shift away from those corporations which are under such duties, move to others who are not, and this is the crucial point. Then the overall effect for the climate is zero. It's not beneficial. That's the problem. Not so much, or not only the unfairness of such a move. And why is all that so? I think it's in the nature of the problem. The climate change is a collective action problem. The climate is a global commons that is overused, so to speak, as a carbon dioxide sink, because nobody is able to exclude others from use, and the use is non-rival also, so that everybody can cause emissions at will, basically. And in such a situation, and that's been analyzed time and again, and I think is in its essence undisputed, in such situations, unilateral action is not capable of moving things forward, because the tuna school that I don't catch will be caught by the next vessel down the line, and because that vessel, that captain knows the situation, I know it too. We both cannot effectively prevent the untoward event unless we can somehow negotiate an agreement between us and enforce it. And Lavanya Rajamani has talked a lot about these agreements and the difficulties they entail, but I think there is no viable alternative to that. And I just want to illustrate this by one slide. Here you can see the distribution of greenhouse gas emissions among major jurisdictions in the world. And 27% is caused by China alone. The EU 27 contribution is rather minor. And there was a report in the media a week ago that while greenhouse gas emissions from coal were decreasing in Europe, but also elsewhere, this reduction was overcompensated by an increase in reduction in emissions in China. And in such a situation, I think it's just not doing any good to rely on unilateral action unless maybe you are the largest emitter or something like China is. But even then, it is accountable for only a quarter of the global emissions. And that brings us to the final question: is leading by example helping things and improving the climate or abating climate change? And for the reasons I've just given, I think one must be very pessimistic that this will really work. And I take it as an anecdotal support of this proposition that even the Swiss, with their abundance of nature, vulnerable nature, and wealth, were unable, the electorate was unable to commit to stronger efforts in combating climate change in a recent referendum. So it doesn't seem to work this way. There is no alternative to international cooperation and agreement. That's it. Thank you very much for your attention.
Thank you very much for this presentation and the critical points made. And we are ready for our final presentation. Judge Eike from the European Court of Human Rights. Judge Eike, the floor is yours. Thank you.
Thank you very much. And thank you very much for the invitation to be with you this afternoon, and my apologies for the technical difficulties earlier. I'm still only talking to you via a hotspot, so let's hope it stays with us. I'm sorry not to have heard the larger part of my colleagues' contributions, but what I perhaps want to do is, looking at it from the European Court of Human Rights, identify some of the challenges an international or regional court, human rights court, will face. In doing that, you'll understand that I won't be commenting on the number of cases, increasing number of cases now pending before us, perhaps most prominently Duarte Agostinho against Portugal and 32 other states, or the Verein Klimasenior in Schweiz against Switzerland. But I think one can identify a number of structural and generic problems which it's worth reflecting on. The first is, and I understand Judge Alvin referred to this, and Professor Wagner did too, the two types of actions, those first addressed against the state, and then those addressed against the against companies and the like. And of course, the Court of Human Rights, like any international court, is ultimately only confronted with vertical, i.e. individual state actions. And in that process, might, as in the Duarte case, the case might come to us directly, but frequently will come via the national courts, following the mandatory need to exhaust domestic remedies. And therefore, what they do, both in the vertical and in the horizontal, is extremely important to us, and will no doubt inform what a court like mine will do. So let me just identify a number of the challenges. The first, I think, is procedural, and it derives in part from the fact that we are a court that was set up in the early 1950s on the basis of the Convention on Human Rights, which was drafted in after the Second World War. And our court is at least to date strictly focused on territorial jurisdiction. So Professor Wagner identified the need for collective action, but our court is only concerned with the responsibility of a state in relation, at least at the moment, of a state in relation to the rights and obligations of those within its territorial jurisdiction. The court has recently and repeatedly refused to accept that there is a cause and effect jurisdiction, i.e. that somebody outside the territory might be able to sue on the basis of the consequences of acts taken within one of the member states. And that, therefore, of course, forces a very narrow view on the causal link between the act and omission of authorities or others and the victims within the territory of that respondent state. Now, the flip side of that is, which is another, and I appreciate these are all relatively technical points, is that both in terms of access to the convention, i.e. the right to bring in action, and the substantive right of access to court under Article 6 under the court's case law requires that applicants have been exposed to a danger or a risk personally, and that the danger should be, or the risk should be, serious, specific, and imminent. Now, one can immediately imagine that the evidential question that would pose for a court like ours, or as a matter of fact, for national courts applying the convention only in relation to climate change actions. On what evidence is an individual likely to be able to establish that the consequences of inaction by a state or action by a state has created a serious, specific, and imminent danger or loss to them? And because the victim status requirement is so narrowly cast, it also means that the court doesn't accept actio popularis and has therefore consistently rejected those type of actions as inadmissible. Now, if one were to overcome those issues, there are then also a number of substantive challenges. The court has now more than 300 decisions and judgments in cases raising environmental related issues, adopting the living instrument approach. But one of the difficulties perhaps with applying the living instrument approach is that it requires the court to identify, and the parties before the court to identify, a common acceptance standard and or something approaching a consensus amongst the 47 member states of the Council of Europe. And even if that might be possible at the programmatic level, at the level of we need to take action to combat climate change, when it comes to the specifics, that is rather more difficult to do. And the court frequently will look at other international instruments in order to inform its judgment as to where such a consensus or such common accepted standards might be. But then, of course, we come to the problem that, for example, the Paris Agreement apparently deliberately did not make a substantive link in its substantive provisions between climate change and human rights, and does not as such contain an enforcement mechanism which the court might be able to look at as reflecting a common approach or a consensus as to what is to be done about failures to achieve emission targets, for example. The other problem is, and this comes to the horizontal and vertical distinction, is that a large part of what a court, it seems to me, can do in this kind of scenario will have to draw on the positive obligation approach. So a positive obligation of the state to do certain steps. Now, there are two ways of looking at it. One is procedural positive obligation, and that is the duty to create a regulatory framework, both in terms of legislation and administrative action. And there is then the domestic court's supervision of the compliance with that domestic regulatory framework. And one might say that the cases we've seen to date, possibly with the exception of the first offender case, are in fact largely cases involving other provisions of domestic law which are being enforced and used as a tool to force action, but not directly the convention or its equivalent in the domestic system. And I think one example of that is the German Constitutional Court's judgment recently. And there are standards which the court can apply to whether that process has been complied with appropriately, whether there were appropriate investigations and studies to predict and evaluate the impact of certain projects, whether there was public access to those investigations, and whether there was access to court to challenge it. But those are all procedural and may be seen, and Professor Radvanti made that point about litigation perhaps not being the first port of call, is one of the difficulties. It is a supervisory jurisdiction that will at best look at compliance with procedural obligations. Now, there's a substantive positive obligation under Article 2 and 8, which includes a duty to protect under a case called Osman against the UK. But there again, you have a very high threshold before you can engage that. Namely, you need to establish that the state knew or ought to have known of a real and immediate risk to an identified individual and
seems that we have some technical problems with the last part of Judge Eike's presentation.
So can you hear me?
Yes, we can hear you. Thank you.
I don't know where you've lost me, so but I will just briefly look at the substantive positive obligation, yeah, and the need to show that an individual, that the state knew or ought to have known of a real and immediate risk to an identified individual or individuals. And one can see that play out, for example, in cases which might be referred to as climate change refugee cases, which we're starting to see in France and in the UN Human Rights Committee, where you have an individual who has a real and immediate risk to themselves deriving from climate change. But how useful that is in the context of litigation within one of our member states about the failure to achieve emission targets, for example, is perhaps rather more difficult to see. And the one light one might see, and this court hasn't yet developed that very far beyond the criminal investigation process, is a recent development in the case law that there may be a duty to cooperate, but that is largely a procedural duty between states to cooperate. Perhaps just finally mention two or three other aspects which really kind of sum up some of the technical details I've given. In terms of the substantive challenges, the court is charged to ensure observation of the convention, which is a very narrow legislative basis. And it's a legislative basis that has no express right to a healthy or viable environment, despite the Parliamentary Assembly's repeated attempts to have a protocol adopted. When one looks at enforcing substantive rights, the court usually grants a wide margin of appreciation to states when one is concerned with difficult socio-economic choices, and it relies heavily on and is required to now under Protocol 15 to apply the principle of subsidiarity, which ultimately leaves seeks to resist the judicialization of public administration, as the court has called it, and leaves government accountable to the democratic processes before it is appropriate for the court to intervene. Of course, as Professor Wagner identified, an essential component in the sense of any democracy governed by the rule of law. So those are a number of technical difficulties, and probably very technical rather than targeted, which I think underline the fact that litigation in itself is probably not the solution to our problem. But while Professor Wagner identified himself as a skeptic, I wouldn't want to be associated with either skeptic or encourager. But it is very clear that certainly litigation in the international courts and in a court like mine faces some not inconsiderable difficulties, which the court will have to address when these cases come to be considered. But it may be helpful to set them out now for the purposes of the European Law Institute's further work on this subject. So thank you very much.
Thank you so much. And thank you all for your very splendid and interesting presentations. Now, what we will do now, we'll go to the Q&A. We have already some questions, and I should say that the floor is open for others to ask questions in the Q&A box. The first question we have is, I'll read it here. In the Dutch case, what was exactly the claim as regards to the state? That the state did not achieve the Paris Agreement's targets, or that it did not do enough? It seems difficult to me, coming from the Belgian legal system, to bring a claim based on the Paris Agreement targets, because there are too many parameters which are beyond the control of the Dutch state to achieve those goals. But if the claim is based on violation of a best effort obligation, what elements are used to establish a violation of such an obligation, since it's my understanding that the mere non-achievement of the targets of the Paris Agreement would not be sufficient? Thank you for this very interesting talk. And I think this question, it could go to, there are various questions in this question. So, but I think first I would like to ask Judge Alwyn if you have a comment, please.
Yes, I think for a good understanding of the Wagner case, it's good to realize that the claim is not so much about the violation of the obligation, but about the future policy targets of the Dutch state. And the Dutch state had certain targets that the state said were in line with the Paris Agreement. And the claimants stated that the target should be more ambitious to reach the effort the Dutch state had to put in. So the case is about what the Dutch state should do to align to the Paris Agreement. And it is about the future policy and the order that was given. Well, it relates to it sets a target for 2020, which is, well, we've passed that now, but when the case was pending, that was still in the future.
Right, thank you very much. And I would like to ask our other three panelists if there's anything you would like to add here. Yeah, Professor Rajavani, please.
If I could just add on the part of the question that related to the violation of the Paris Agreement targets, and whether you could actually bring a case for that. I mean, this of course would depend on, the jurisdiction and to what extent international law automatically becomes part of the law of the land or not, whether it's a monist or dualist system. But having said that, the nature of the obligations in the Paris Agreement, as I said in my presentation, in relation to the nationally determined contributions, is a procedural obligation attached with some obligations of conduct, but it's a procedural obligation, not an obligation of result in relation to the content of the nationally determined contributions. So it is at that level difficult to bring a claim for violation of sort of the targets themselves, because it's not an obligation of result. Having said that, there are obligations of conduct attached and normative expectations attached to the nationally determined contributions. in relation to the due diligence that is required of states in fulfilling the targets they've taken on, and that there is a standard of conduct that is used to determine when those due diligence obligations are being met or not met. And there are many factors that go into determining what that standard of care is with respect to that due diligence duty. And among the factors that one takes into account are context-specific and regime-specific factors, such as, for instance, the temperature goal in Article 2, sort of 1.5, aspiring to 1.5 degrees, well below 2 degrees, and also the nature of the consequences if you don't meet the temperature goal. So if those consequences are irreversible, if those consequences are permanent and widespread, as the IPCC tells us it is, with ever more increasing certainty, in fact, it's now considered unequivocal, the standard of care to which that due diligence obligation will be benchmarked is much higher. So I think even if it's an obligation of conduct, there are due diligence duties attached to it, and the standard of care is very high. So I think it's certainly possible to derive some robust sort of support for ambitious national contributions from the international framework, not just the Paris Agreement, but also general international law, customary international law in relation to no harm and due diligence. Thank you.
Thank you very much. We will move to the next question, and it reads, in Belgium, the judge has held in June 2021 that the state was liable for non-respect of climate norms, but refused to condemn the state to the respect of a percentage of reduction of CO2 norms. Considering that it was in the power of appreciation of the state, I think that to make the respect of the CO2 norms efficient, a specific performance in terms of reduction of percentage was the sole good solution. Do you agree? And thanks for this seminar. And I think this is a question that we really can address to all four of you. But if we start with Professor Wagner, please. If you have a comment.
Yes, I think it is in essence the same question that was asked a minute ago. Where do we get specific duties, or where do these duties come from? We've heard they come from the Paris Agreement, but the Paris Agreement doesn't impose particular duties and doesn't specify quantitative goals. These are all up in the air. And what the German Constitutional Court did, and I think the approach of the Rechtbank Den Haag was very similar, was to use scientific evidence that came from an approach which you could call the budget approach. The idea was that greenhouse gas emissions can rise only up to a certain percentage of greenhouse gas in the atmosphere until the 1.5 or 2 degrees temperature goal is breached. And then you have sort of a quantity, a defined quantity of greenhouse gas emissions, and then you impose a kind of proportional liability. What you say in essence is that every jurisdiction has to reduce its emissions in proportion to all the others, so that the budget or that the total emissions remain within the budget. Now, this, I think, or I would readily admit, this is maybe the best we can do. At least I have no better idea to quantify emission reductions, which is another way of saying to quantify the remaining emissions budget, that's the positive version, for any jurisdiction, or even with a view to any corporation or any individual. With that approach, I could tell you how many greenhouse gas emissions you're allowed to produce in the remainder of your lifetime. And this sounds maybe the best we can do, but one must not overlook, this is an approach with many unknown variables. for instance, whether we have that budget, it depends not only on greenhouse gas emissions, it also depends on the development of plants and other biomatter that affect the greenhouse gas balance in the atmosphere. They certainly depend on the development of the world population. If it increases at the current pace, that will look altogether different from a scenario where it increases at a slower pace or not at all, and so on and so on and so on. So even if you accept all the assumptions about the impact of greenhouse gas emissions on the climate and on temperatures, and which has a lot of uncertainties in itself, then because the number of greenhouse gas emitters is not limited and is a dynamic function, as is the consumption of greenhouse gases by plants and other biomatter, this is a very, very artificial setting. And what we essentially do, or what I understand courts like the Den Haag court to do, and the German constitutional courts as well, is to say, well, in this situation, we just grab a straw. We assume that it's a fixed budget. We assume that we know all the variables that I indicated, or we hold them constant, and then we impose a kind of proportional obligation. But one must say, with other matters, I think democracies would not be prepared to act or to impose such serious limitations on the political process on such uncertain grounds.
Right, thank you very much. We just got another question which I will bring up, and we'll see if we have time to get back to the question that we just addressed, and that is a question Professor Wagner brought up, activist judges. It sounded to me that he was advocating for judicial advocacy in this area. I'd like to know Judge Ahlwin's and Judge Eike's thoughts. So first Judge Ahlwin and then Judge Eike, please.
From the perspective of the judge, when cases are brought to judges, you have to decide on them. And there are systems like, for example, in the States, there's the political question doctrine that gives a judge opportunities to say, okay, this is a political question. I'm staying out of this. But in most, at least in the Dutch system, the judge has to decide on the case that is brought to him. So, well, that's my comment on activist judges.
Right, thank you very much. Judge Eike, please.
Mm-hmm. Thank you. I would subscribe to all of that. And the Court of Human Rights has also repeatedly emphasized that the fact that a question is political, or the motivation for bringing it may be political, does not stop it being a legal question which the court has to answer within its limits. And I think that's right. But that's why I identified some of the limits which are set by the convention at the moment. And that's where it may be that national law offers a wider canvas of the law to work with. But as I said, we have one convention from 1950 with a few protocols, none of which protect the right to a healthy environment. Nation-state focused, victim focused, but individual victim focused. And all of those create the difficulties. But it raises this political question, this political or activist judges question raises another issue, which I think also came out of the question you had before, the Belgian court, if I understood it properly, who found a breach of the requirements but refused to grant a remedy. And there is an issue, and one can look at this from both ways. I mean, my court normally grants declaratory relief or just satisfaction in the form of compensation. So we don't generally assume that we have the power to direct particular action to be taken. But it does raise a question, I think that applies to national courts as it does to us. The more directive you are in your judgments, and for all the reasons Professor Wagner and others have alluded to, the state does not or cannot comply. What does a court do then? And I understand in Orende that question may be coming or may be currently acute, and a non-compliance with judgments in this respect, what do they do to the standing in the court and its moral authority or legal authority going further? I mean, an example is the European Court of Justice case of Deutsche Umwelthilfe, where, as I understand it, a German senior administrative court put a question to the CJEU about what tools EU law gave it or required it to have in order to force a government minister or a mayor of a German city to actually comply with an order, very specific order about meeting EU emissions targets. And that kind of question is one which I think puts judges in a very difficult position, and in a society governed by the rule of law and the separation of powers, makes it very difficult for judges. So I think, yes, there is no political, there's no exception for political cases, but they have to be done within the legal framework within which each of us judges sit. And in a sense, there's always the question, how far is what we do and how far do we develop the legal framework within which we sit legitimate and in an international court potentially also acceptable to stakeholders?
Right, thank you very much. We will soon be running out of time before we will get to the closing remarks. I would just like to ask if there's anyone who would like to add something here from the panel. Anything in respect of the questions that we've had so far?
If I could just very briefly, Professor Anderson, on the activist judges question, which I know was not directed to the academic, was directed to the judges, but I just want to briefly add that, I mean, ultimately, judges are dealing with legal issues, even if they have political consequences and political implications and are political issues elsewhere. There are legal issues within them and legal frameworks. And there is a interpretative and application-oriented sort of function that is being performed. That function can be performed in an imaginative way, creative way, or it can be performed in a mundane way. And I think what new challenges and issues like climate change demand is that there is some imagination used in the application and interpretation of the law, because these are situations that are polycentric. These are sort of problems that are super wicked, and we need imaginative solutions. It is imaginative solutions within the framework of the law, but the imaginative solutions. I think the term activist judges is somehow used quite pejoratively in the literature, and I think what the climate change problematic is posing for judges is sort of a demand for some imagination. That's all, within the framework of the law, but a demand for some imagination. And I know that the judges on this panel and many others are entirely up to the challenge. So I'm sort of looking forward to seeing where we go on climate litigation. Thank you.
Right, thank you very much. And thank you so much to all the panelists for keeping the time. It's very impressive, and thank you so much for your very interesting contributions and thought-provoking discussions here. And I also would like to thank you for the questions. Now we are coming to the closing remarks from my very dear colleague, Professor Alberto De Franceschi. Alberto, please.
Thank you very much, Eric, for brilliantly chairing the session, and thank you so much to each and every one of the speakers for their brilliant thoughts and for bringing forward our reflections on this multifaceted topic. I will not recall all elements and arguments made, just some thoughts and picking up some of the most relevant elements on the table. We identified several gaps in tackling the climate change issue: the ambition gap, the accountability gap, and the fairness gap. And the lively discussion brought up and highlighted the circumstance that the emission reduction goals of the Paris Agreement are not sufficient to reach the ambitious goals we are facing. And therefore, the number of greenhouse emitters is, as it is a moving target, the only one way forward is to look at the harmonization between jurisdiction and to look at the circumstance that global leakage highlights that products and services will relocate to other jurisdictions. So there is no alternative to international cooperation, and the most relevant problems are those of positive obligation of supervisory jurisdiction and of creating a framework which works together at an international level for avoiding also competition problems and distortion of competition. And so therefore, I'm particularly thankful to all speakers who took the floor today, and for those who contributed with questions, for bringing forward our thoughts and our reflections in the framework of this project. And you are mostly welcome to contribute also in the future for giving us suggestions and inspiration for towards the principles that this group will elaborate in regarding climate justice. So thank you very much to all the panelists and to those who participated in this webinar, and see you soon again. Thank you.